and good afternoon from wherever you're joining us from to another Africa Digital Rights Hub webinar. We undertake this webinar as part of our capacity building efforts around digital rights issues across Africa. This one we're particularly undertaking in the light of the IP month, and today being International Intellectual Property Day, we want to use the opportunity to particularly explore the intersection between AI and intellectual property. Interestingly, in the last few months, we've seen some interesting decisions around the world, particularly some of them coming from China and the like. And it's quite interesting when, for those of us in Africa, especially looking at the IP landscape in Africa, to start really thinking around these issues. And so with the support of our abled experts, who I'll introduce shortly, I am very happy to have this opportunity to discuss this issue today. And so our agenda today is to really look at IP and AI in Africa. And we will be joined by Madam NanaAma Botchway, a managing partner of Dowuona Company, Mr. Giles Pratt, partner Freshfields Bruckhaus Deringer, I hope I pronounced the name right, and Mr. Alex Calloway, an international transaction advisor in the UK and a UK counsel at Dowuona Company. Gentlemen and ladies, welcome to our webinar today. Just a few housekeeping duties. When you're speaking, you can unmute yourself and open up your videos. That is, if you're speakers. For those that are the attendees that are joining us, there's a Q&A session that you can put your questions at. If you have any questions whilst our experts are speaking or presenting. And then for those of you who are also joining us live on Facebook and other social media pages, if you have any pressing questions, you can post it on those pages, which we are following, and we will try to bring it to the attention of our speakers. Having said that, I think I will bring right away, so that we don't waste too much time talking, I'll bring on board Madam NanaAma Botchway to start the conversation this morning. NanaAma, thank you. Can you please unmute?
Yes, good morning. Hi, everybody. It's good to be with you here today to talk about this very exciting this very exciting topic that has so much potential for our continent. AI offers enormous opportunities. AI technology can be deployed to tackle some of the major challenges that our continent faces in diverse areas, including climate change and the environment, energy and electricity, agriculture and food security, medicine and healthcare, financial access through fintech and AI loan products, governance, elections, and democratic processes. So across the continent, there are examples of innovations, innovative startups and organizations, both local and international, who are using AI technology to address many of these challenges. For example, in Tanzania, rural farmers are using an AI-assisted app called Nuru to detect cassava crop diseases at an early stage. In Nigeria, telemedicine and artificial intelligence have enabled health tech platforms to emerge and allow doctors to treat patients in under-resourced areas. In Kenya, Chimetrica, a social enterprise, has developed an AI-based application that can assess malnutrition levels by using facial recognition and a processing algorithm. And here in Ghana, a number of fintech startups are using AI, machine learning to analyze credit and financial transaction data to provide low-cost loans and other financial products. So there are many, many, many more examples. More broadly, the successful deployment of AI technology could enhance productivity, optimize resource allocation, and drive innovation across various sectors, helping to deliver economic development. The estimates available suggest the numbers involved could be significant. For example, Egypt projects that its adoption of AI will contribute almost 10% to its GDP by 2030. On a continent that already has the youngest population in the world, and will soon be home to 1 in 5 of the world's citizens, the ability to leverage such a powerful tool could be a real game changer. However, AI brings risks as well as opportunities, both globally and particularly for Africa. And not all the news is good. As you know, Africa faces challenges in capitalizing on AI technologies, including high costs associated with infrastructure installation and the need for capacity building and education. And Africa's situation means some of the risks in AI technology that have been considered internationally are a particular concern for us here. For example, the use of AI technology can perpetuate existing racial and gender biases. AI technology can increase the risk of misinformation, creating echo chambers, fake news, and media and voter manipulation. AI technology could deepen social, political, and economic inequalities and further widen what is already a significant digital divide. And relying on international IT technology can increase dependencies and lead to what has been described as algorithmic colonization. Most of the AI systems operating within Africa are adapted, imported, or even hosted from abroad. For instance, in Nigeria, one of the most technologically advanced countries in Africa, more than 80% of the technological software used in the country is imported. At present, the governance and regulatory framework across Africa to manage these risks is in its early stages. In the 2023 Oxford Insights Government AI Readiness Index, Sub-Saharan Africa had the lowest average score of any world region in the index. Mauritius, the highest ranked African country in the index, was ranked only 61st in the world. There's been some progress in the past year. A number of countries have now adopted national AI policies or frameworks, and there's been a lot of work done at the regional, continental level through the African Union and other international organizations. But there's still further to go, and the clock is ticking. Internationally, the key players such as the EU, the US, and China have all already put AI regulation in place, and international AI policies and regulation are being developed. But African voices have largely been absent from these global discussions. So if African governments are to put in place the appropriate legal and policy frameworks to be able to seize the opportunities and overcome the risks of AI, they must do so soon and on their own terms. In today's session, first, Giles will look at the global perspectives on AI and IP regulation. looking at regulation and policy frameworks in key regions such as the US, Europe, and Asia, and best practices and emerging trends in AI and IP regulation from around the world. Next, we will look at the current state of AI and some IP regulation in Africa, looking at both national and regional frameworks. Then we will look in more detail at the key differences and challenges with AI regulation in Africa versus the rest of the world, examining what are the unique challenges faced by African countries in regulating AI technologies and protecting IP rights. We will then consider opportunities for harmonization and collaboration and the role of international organizations, governments, and industry stakeholders in supporting AI and IP policy development in Africa. Finally, we will sum up the key takeaways on AI regulation in Africa. What are our particular risks and opportunities for our continent, and what lessons and practices we can take away from global regulation. So with that, I'd like to turn over to Giles to talk to us about global AI regulation. Giles?
Thank you so much for that. It's great to be here with you both. Today, I'm going to take the group through a tour of emerging global AI regulation and, as it's World IP Day, how AI is impacting existing intellectual property rights. Let's start with AI regulation. As you rightly said, we all know there's been an explosion in innovation in AI over the last few years. And that means that governments and regulators across the globe are facing really a double conundrum. How are you going to support the adoption of a very fast-moving technology across the world whilst ensuring that it is being used safely and appropriately? And whilst I think it's fair to say AI has been around in different guises for a long time, it's the recent innovations in AI that have led to a range of regulatory reactions across the world. And you do see different countries taking very different approaches, often because of different cultural values, political priorities, perceived national interest. But there is kind of broad agreement that there is an increasing need for guardrails to be put in place around certain AI implementations. If I tour you through this map, the key parts of it to call out are that in purple, we've got areas where there is an AI-specific law in force at a national level. You'll see not very many. In pink, the AI-specific laws that are planned with published draft texts. And in orange, the countries where you have policies, guidance, kind of other similar kind of soft law aimed at AI regulation, but not really kind of a particular legal instrument. And AI regulation can take on a range of different forms, even kind of within that. So you've got some new general wide-ranging AI-specific laws, and the EU AI Act is a good example of that. That takes a risk-based approach to AI regulation. It bans systems that are deemed to have an unacceptable risk. It specifies certain rules associated with high-risk systems, and there are various other kind of tiers down, which I'll explain in more detail in a moment. Then you've got countries that have decided to target specific AI use cases or technologies. China is a good example of that. Again, I'll come on to explain that in more detail in a moment, but there they've passed a series of AI laws that are specific to particular ways in which AI can be deployed. And then you've got a sort of general repurposing or updating of existing laws that might be technology or sector neutral, for example, privacy laws, or you might have an updating of sector specific laws, for example, in relation to financial services. And we've seen a fair bit of that in the UK. People might have read there's a white paper in the UK that has said that rather than jumping to AI specific regulation, we are generally going to rely on 5 cross-sectoral principles, points that people will have heard time and time again, safety, transparency, fairness, accountability, contestability. And we take those principles and we say they should apply to AI generally and should be implemented by existing regulators through existing regulatory frameworks. And then you've got a range of countries around the world, including in Africa and more broadly, for example, in Australia, where people have published kind of voluntary guidelines, often aimed at thinking about some of the ethical issues associated with AI. And then sitting across the top of that, you have coordination between countries. So international action, which we'll discuss later, where countries are looking at how to align on their approaches. And you see some of that through the G7, through various AI safety meetings, including in the UK and shortly in Korea and then in France. So now let me turn to some of the laws that I've highlighted. I'll start by giving an overview of China's approach to regulating AI, where we've got this legislation for specific use cases. Then I'll get into the EU's AI Act, which, as I said, is the first global general AI regulation. So starting then with China, China was actually first on the scene with AI regulation that is in force. And the slide gives you a reminder of the three pieces of regulation that are already live there, and each targeting a specific type of AI, and there is some degree of overlap between them, I think it's fair to say. So you've got the first law, which is around algorithmic recommendations, and that was first to introduce a requirement for filing algorithms with the Cyberspace Administration of China, and it does require a security assessment of those algorithms. So there is a degree of state oversight there, and that is actually a theme that has played through these other regulations. Secondly, China's deep synthesis regulations, what you and I would call deep fakes. But this requires the labeling of deep fakes and certain consumer and other kind of user protections, for example, requirements for content moderation, and that's been enforced since January of 2023. And then following that, you've got China's interim measures on generative AI systems, and they came into force last year, and they tackle a wide range of perceived harms, including around the misuse of personal data, potential discrimination in the output from generative AI, questions around reliability, and also IP infringement. These measures also require that the provision and use of Gen AI services will uphold China's core values. And as I mentioned, this also includes a requirement to file a model with a central authority in China. Just maybe sort of stepping back as a more general observation, those interim measures on generative AI are pretty short form for a very complex technology, and they're not very specific about how to comply with them. And so those rules were supplemented towards the end of last year by a Chinese government organization called the National Information Security Standardization Technical Committee, rolls off the tongue, and they released a draft document that basically proposed detailed rules for how to determine whether a generative AI model is problematic. And that standards document is extremely detailed. It sets out particular criteria to determine when a data source should be banned from being used in the training of a generative AI model. It gives metrics on the exact number of keywords and sample questions that should be prepared to test a model. So it's really setting out a blueprint for how people should be taking a model to market in China. And just to offer an example, the standard that I've got up on the slide requires companies not only to diversify the kind of linguistic data that are being used to train a model, say a mixture of languages and formats, but also to assess the quality of their training materials. It says by randomly sampling 4,000 pieces of data from one source, and if over 5% of that data is considered illegal and negative information, then you have to blacklist that body of data for future training. And that percentage might seem quite low at first, but I'm not actually clear on whether companies feel able to implement that in the real world. If you were just looking at large libraries of data that are publicly accessible, how would you judge whether 5% of Wikipedia falls on the wrong side of the line, for example? So there are kind of clear challenges with having a law which is very generic, and there are also challenges with having a law which is extremely specific. If I turn then to the EU, and as I said, that's really the jurisdiction that's moved the furthest and fastest with its AI Act, which is probably the most wide-ranging attempt so far to regulate AI worldwide, not least because it has extraterritorial effect for those who are touching the EU market. The purpose of the legislation is really to harmonise rules across all AI systems in the EU. The intention is to ensure that those systems are built in and deployed in a way that respects essentially kind of fundamental rights and freedoms of individuals and kind of associated values across the EU. And the end goal is to have systems that are fair and transparent and are not harmful, particularly to vulnerable people. This law is really fundamentally a product liability style law. It's placing onerous and quite prescriptive obligations on certain types of AI systems. And like other product liability legislation, at least in Europe, it governs kind of what you have to do if you're a developer or a deployer of a system. And it sets out particular standards for how to conform to its rules. How does it work? Well, you can see from this pyramid that it is taking a risk-based approach. You categorize systems into 4 risk categories: unacceptable, high risk, limited risk, and then minimal or no risk. And you won't be surprised to hear that the higher the risk, the stricter the rules. You've got prohibited systems at the top of the pyramid, which are essentially systems that pose an unacceptable risk, and they are banned completely within a relatively short period of time. And they include things like social scoring based on social behavior or your kind of personal characteristics. They include biometric categorization systems that are based on biometric data, and they include AI that's used to exploit the vulnerabilities of people, things which as a society you would instinctively not want to see. In the yellow zone, you've got models with limited risk. So certain systems that are intended to interact with individuals, like chatbots or things which could allow for impersonations or deepfakes, they're subject to a transparency requirement. So people are supposed to be told that they are interacting with an AI and not with a human, but there's otherwise not a particularly high risk associated with that AI use case. And then you've got high risk systems. So systems that are said to pose a high risk to fundamental rights to individuals, but which are allowed to be on the market subject to a conformity assessment. And the details of that conformity assessment are still being worked out, but it will require people to demonstrate that their system complies with essentially mandatory requirements for trustworthy AI. And the list of high-risk systems is closed. There's a schedule to the AI Act that tells you what you're looking at, albeit that can be amended by the European legislature. And it includes things like safety components used in the management or operation of critical digital infrastructure and vehicles. It includes AI used in relation to education and vocational training, for example, to evaluate learning outcomes, determine access to or admission to training institutions, to monitor cheating. And it's also very relevant in financial services. It tags evaluating the creditworthiness of someone or establishing their credit score as something that is potentially high risk, as well as the pricing of life and health insurance. And when you get into how you're going to get a high-risk system to market, you have to look at what the conformity assessments are going to require of your system. And that will include putting in place risk management systems, new rules for data governance, certain technical documentation around instructions for use. There's a degree of record-keeping requirements designed to enable people to essentially log and trace the way in which a system has been functioning through its life cycle. There are transparency requirements so that users are aware of what they're engaging in, as well as human oversight requirements so that real people are able to be assigned to understand the capabilities and limitations of the system and monitor its operation. And there are also expected rules around accuracy, robustness, and security. So that's the kind of risk tiering in the AI Act. And then you have alongside that a separate set of rules around general purpose models. So regardless of risk, the Act contains specific rules on general purpose AI. What people will have heard referred to as foundation models, including Gen AI models. For example, the models which underpin the ChatGPT service and various other generative AI systems. And the Act sets out some baseline obligations for general purpose models. They include documentation and information sharing obligations so that the EU authorities are able to have oversight of those models. Includes obligations to comply with EU copyright laws when training those models and to publish summaries about the content that was used in relation to that training, so that then IP rights holders could separately follow up if they were to choose to do so. And there is also an obligation to consider codes of conduct that are going to be implemented alongside the AI Act, including to, for example, minimize the environmental impact of the training of models, which of course is a big burn on the compute side. And then you've got an extra tier of obligations for general purpose models that create what's called a systemic risk. And that's basically judged by reference to compute power. And there are additional obligations on those, including to conduct systemic risk assessments, to run adversarial testing, what some people would call red teaming, and to report incidents to the European Commission, and also to ensure a high degree of cybersecurity protection. So you can see that this is quite a comprehensive set of regulations. It is focused, first of all, on high-risk implementations of AI, but it is also taking aim at general-purpose AI that could be used for a wide range of things, and it has a particular layer of regulation associated with high-powered general-purpose AI because of the perceived sort of systemic risk that could result in. And there is also there an interface with intellectual property law. You won't be surprised to hear that part of the negotiation of the AI Act it did involve taking into account the creative industries and the way in which their content was being used, particularly in relation to the training of foundation models. And so that has played through into that disclosure requirement that I tagged. But there are then kind of separate issues around the intersection of AI and IP. That, as people will know, raises a variety of quite interesting questions, many of which are still uncertain, subject to litigation, and definitely kind of areas that we're all going to be talking about for the next few years. I was going to offer today just a high-level overview of some of the main issues that are of interest in that space. And I know that these are coming up in different ways in different jurisdictions across the world. I was going to suggest breaking it down by reference to inputs and outputs. And when I say inputs, obviously I mean the information that an individual or an organization is kind of giving to a machine learning model. In the Gen AI context, that might be text, it might be images, it might be any other content that you prompt a model with. And I'm also thinking here about the body of inputs that you use to train a model. So it might be content that is used to make the model, or it might be an input that you are putting into a model that already exists. And if you look on the left-hand side of the slide, I've kind of offered a few thoughts on the IP issues to navigate on inputs. Firstly, risks to confidentiality. If a user includes confidential information in prompts for a public model, then there is a risk that you lose the confidential nature of what you are sharing, because you are essentially sharing that with a third-party public model in a way where others may be able to access it, and in a way in which the results may be made more broadly available. And in certain circumstances, you might also find, so it's worth checking the terms, that your data can be used to train AI models further, and that then potentially raises the risk that this data is shared more broadly and even disclosed outside of the provider of that model, for example, in the outputs from later queries to the model. I think there's also a question around risks to exclusivity where you are using public models. So patent protection, for example, can only be sought for inventions that are new. New means that you haven't disclosed something to the public, and there is a real risk that were an organization or an individual to disclose aspects of their invention to a third-party AI model, that they could potentially lose the right to claim patent protection over that invention in the future. And I think both of those risks really mean that sophisticated organizations are putting guardrails around things that can be put into AI, and particularly guardrails around how they share information with public AI models. And so, for that reason, we see a lot of the organizations we work with setting up private instances of these models so that they can use them within their own private environment. Another very relevant point for people building AI systems is to think about issues associated with breaching third-party rights in the training data. So some AI models are trained using data that's been scraped from the internet. That may include, of course, copyright works. Even where training data has not been scraped, it might have been accessed, for example, under a license that doesn't permit the data to be used in the training of AI models. And we're seeing quite a lot of people change the terms on which data is made available to address that type of friction. Now, the courts are yet to resolve whether generative AI developers, providers, customers, users can be liable for IP infringement in those circumstances. But you really have to look to the types of defenses to copyright infringement that exist in national copyright laws, and they are not fully harmonized around the world. So, as people will know, some countries' IP laws include exceptions to copyright infringement that might apply to generative AI. That includes exceptions for fair use. There are separate exceptions in certain countries for what's called text and data mining, or maybe even temporary copying. But a lack of harmonization across countries means that you could get a different result in litigation in different parts of the world. Certainly where I am in the English courts, there is ongoing litigation brought by Getty Images as to whether certain generative AI model providers have breached copyright when training their models. There is similar litigation that's ongoing in the US. I genuinely think this is going to be a live issue for quite some time, and people will have seen some of the larger tech providers weighing in on this point as well. If I then flip to the output side of the equation, we are thinking here about the risks and issues caused by using and relying on AI-generated outputs. The first point to note is it's not always obvious that something which is generated by AI is capable of being protected by IP. In the UK, in a number of other jurisdictions, IP laws as currently drafted are kind of based on the notion that you're typically going to have a human creator. It's not yet clear whether we're going to respect that IP rights, among them copyrights, potentially also patent rights, can arise in outputs generated by an AI model. And for the moment, there is a possibility that IP rights don't arise in those outputs. You've got in the US, for example, the US Copyright Office issuing guidance on registering works containing material that's been generated by AI. And they are effectively saying that you have to have a creative contribution from a human, and that just suggesting something in a text prompt may well not establish copyright, as the prompt is just kind of influencing the output, it's not determining it. And then you've got a different decision in the Beijing Internet Court in China that says that a user owns the copyright in an AI-generated image because they adjusted the prompts and the parameters so the image reflected their aesthetic choice and judgment. So I think you're going to see quite some difference in the approach across that, and we haven't yet gotten to a stage where people are proposing a global recognition of copyright in generative AI outputs. The other thing to bear in mind is that your output from a model could infringe third-party IP, as well as kind of giving rise to issues under privacy laws, defamation laws, discrimination rules, and so on. The concern there is that some people, I think, might naively assume that just because something is generated by a model, it hasn't copied something else in the world because the model was trained using so much that is out there. And in fact, there is, I think, not an unrealistic risk that some of the outputs generated by AI have borrowed a sufficient amount of the input data that was used to train them that they infringe, and the ways in which some of the people who provide models might stand behind that infringement risk are relatively limited, although there has been quite a degree of fanfare made about them by many organizations, including, for example, Microsoft. And then finally, just to bear in mind in the deep fake space, that in some jurisdictions there is IP or adjacent protection associated with the likeness of an individual, someone's personality. That can arise in human rights, it can arise in IP law, in unfair competition laws. And so if you are using AI for deep fake purposes, I think worth bearing in mind that mimicking of a likeness and voice can give rise potentially to IP, human rights, defamation, potentially fraud, and other legal actions. Again, we've not seen too much action in that space. I did mention earlier that China's already passed regulations applying to deep synthesis, and I also explained that the EU's AI Act requires transparency associated with deepfakes. But I think here you've really got a collision between IP rights and AI regulation that's going to continue to evolve over the coming years. I think enough from around the world, and great to bring this closer to home. I think we're now going to hear from Alex on the current state of AI regulation in Africa.
Thanks, Giles. I think one of the things that's interesting when we look at AI regulation in Africa, and we'll go through this map, is how some of those themes that you've picked out in the EU, in China, in the US, play out in our local context. So we don't yet in Africa have a unified regulatory framework for AI, and no country on the continent yet has any AI-specific law or legislation on the books. But what we have seen in the last few years is lots of policy developments, position papers, and government activity thinking around how AI can be used for development and how it should be regulated. So our last count, there were 7 countries, as set out on this slide, who have adopted national AI policies or national AI strategies. They're the dark orange ones here. The first of those, Mauritius, adopted their artificial intelligence strategy all the way back in 2018. And that policy really took a development-focused approach, looked at how Mauritius can use artificial intelligence technology to help develop the nation and advance socio-economic growth, bring development to all of the people in Mauritius. And to do that, that policy looked at a number of priority areas, including manufacturing, healthcare, financial technology, and agriculture, where AI could be used particularly to drive development. And lots of the other AI policies that are out there in draft have taken that similar development-focused approach. We've seen it in Rwanda's national AI policy, and you'll see on the slide that Tunisia's AI policy is called the National AI Strategy for Inclusive and Sustainable Development. But I think the Egyptian example is an interesting one for how that plays out, because they adopted their national AI strategy back in 2021, and that had a similar sustainable development focused approach. NanaAma referred to earlier how their target was to have 10% of the GDP built on AI technologies and AI industry by 2030. But then in 2030, that national development focused AI policy was followed by the Egyptian Charter for Responsible AI, which is actually looking at how AI can be used responsibly, looking at some of the ethical issues in AI deployment and development, which we'll come on to, and trying to build into the Egyptian context some of the international standards we've seen from UNESCO and other organizations on the responsible use of AI. Then we have lots of countries in the lighter orange on this slide who are working on their AI policies and either have a draft up and running that's waiting for approval or organizations working on it. So in Uganda, for example, there's a task force to advise the government on using AI to fast track development. In South Africa, there's a presidential commission that's been integrated to look at the 4th industrial revolution, and how AI can be used to support that. And then closer to home here in Ghana, we have a draft national AI policy that is being developed by the Ministry of Communications and Digitalization, which is in draft form and hopefully will be presented to Cabinet shortly for their review. Then in other jurisdictions, rather than having standalone AI policies, you have policies governing AI folded into a broader digital strategy for the nation. Benin is an example of that on this slide. So they have a digitalization countrywide policy that includes AI elements in it. And then as Giles mentioned, in the case of the UK, you have some jurisdictions where either instead of or complementary to the national AI strategy, there are sector-specific regulations and sector-specific policies and rules being launched. In Mauritius, for example, the Mauritius Financial Services Commission introduced the Financial Services Robotic and Artificial Intelligence Enabled Advisory Services rules, which provide an actual regulatory framework within the context of Mauritian financial services law to address the adoption of artificial intelligence in the provision of financial advisory services. For example, we talked about the credit scoring use of AI earlier. So across the continent, governments have been busy on their national AI strategies, national AI policies. None of these yet are reflected in legislation, but some of them refer to draft legislation being proposed in short order, and I think that's what we'll see soon. And NanaAma will talk about what we've seen on a more continental-wide approach across Africa.
Thanks, Alex. So, over the past several years, Africa has seen a number of continent-wide and regional AI policy-making efforts, as Alex has described. The timeline on this slide shows the initiatives adopted on the continent and reflects the growing commitment to using AI for sustainable development, whilst recognizing its inherent risks. The first critical step for a regional approach to AI governance and regulation came in 2019 when the AU Ministers for Communications and ICTs initiated the Specialized Technical Committee on Communication and Information Technologies and adopted the Sharm el-Sheikh Declaration. Amongst other things, this declaration recommended the establishment of a working group on AI to study the creation of a common African stance on AI, the development of an Africa-wide capacity building framework, and establishment of an AI think tank to assess and recommend projects to collaborate on in line with Agenda 2063 and the SDGs. Following this, Smart Africa, an organization established in 2013 by various African heads of state to advance information and communication technologies and digital development, and the government of South Africa published the Blueprint for Artificial Intelligence in Africa in 2021 with support from the BMZ and GIZ and input from Rwanda and Uganda, the AU and other stakeholders. And the blueprint sets out 5 pillars for a successful AI strategy for African countries. The first is human capital, including a technologically skilled workforce and AI talent. Second is from lab to market and the design of AI solutions that can be scaled up and attract venture capital investment. A third is infrastructure necessary for developing AI locally, such as access to data and high-powered computing. Fourth pillar is networking through an expanded ecosystem of public and private bodies and partnerships, including international organizations and industry bodies. And the last pillar, most interestingly for us, is regulations to address emerging challenges and opportunities for AI at national and sectoral levels. Also in 2021, the African Commission on Human and People's Rights adopted Resolution 473, a resolution on the need to undertake a study on human and people's rights and AI, robotics, and other new and emerging technologies in Africa, urging the development of a comprehensive legal and ethical governance framework. In 2022, the members of the African Development Community, SADC, adopted the Windhoek Statement on Artificial Intelligence in Southern Africa, which is intended to facilitate designing and implementing AI policies among member states, and recommends the SADC member states co-create Africa-centric governance frameworks for AI, emphasizing sustainable and ethical development aligned with strategic national goals. Last year in 2023, the African Union Malabo Convention on Cybersecurity and Protection of Personal Data came into effect after the 15th ratification by Mauritania. In February of this year, the Digital Trade Protocol under the African Continental Free Trade Agreement was adopted. This protocol addresses key areas such as data protection, cross-border data transfer, data-driven innovation, and cybersecurity. It also mandates state parties to promote the adoption of emerging and advanced technologies. It also mandates state parties to establish governance frameworks that ensure these technologies are used ethically, safely, and responsibly. In March of this year, the AU Development Agency, NEPAD, unveiled a draft white paper and roadmap for a continent-wide AI strategy entitled Regulation and Responsible Adoption of AI in Africa towards achievement of AU Agenda 2023. Alongside this regional activity, African countries have also participated in broader international policymaking. Last year, for example, African countries adopted UNESCO's recommendation on the ethics of AI, which provides a guiding framework for responsible AI development, emphasizing principles such as human dignity, transparency, and environmental protection. Now, we had a slide that Alex was going to speak to briefly. And Alex, I know that we're concerned about time, but maybe you could just give us a high level overview before we come to my high level overview of the IP considerations and data protection.
Sure. So we thought it would be worth spending just a couple of minutes talking in a bit more detail about this African Union white paper, because we think it will be adopted by the African Union heads of state at their next meeting in February next year. And so will really form the basis for AI policy and AI regulation on the continent going forwards, and potentially ultimately any sort of continental regulatory regime that we see. So this white paper, it drew on the pillars that NanaAma mentioned from the Smart Africa blueprint. You'll see it's added one on the slide. The first of those pillars was human capital development, where the policy looks at the need to build education, skills, and work readiness for people in the continent to be able to participate properly in the AI economy. The second pillar was building local infrastructure, local data foundations to try and reduce the reliance on international data centers and international infrastructure, so Africa can build in Africa the equipment that it needs itself. Thirdly, and again, most relevantly for us, it was a pillar that talked about the need to create an enabling environment for AI development and deployment. And a big part of that was regulation. And the policy in the white paper talks about the need to harmonize regulation across African countries and across markets so that we can have a really true continental-wide development framework, drawing on the African Continental Free Trade Agreement to allow trade and businesses easily to move between countries. The fourth pillar was on the AI economy, what we need to do to help AI drive economic and socio-economic development. The fifth pillar was talking about building sustainable partnerships, which we'll come on to when we talk about regional harmonization and what's happening internationally. And then interestingly, pillar 6 recognized the need that it's all very well having these policies and these pillars, whether they're regional or national, but really what you need to do is to monitor and evaluate how this is working in practice. And so the AU white paper recommended the establishment of an AU strategy committee that would be responsible for monitoring AI implementation and development across the continent, looking at how both the regional framework and the country states' national policies were contributing or not contributing to AI and helping achieve the opportunities, but also managing the risks that we've spoken about. And then on the flip side, the African Human Rights Organization, their resolution took a very human rights focused approach, as you would expect. And interestingly, it talked about the need for the sufficient consideration of African norms, ethics, values, and rights in the development of these AI policies and AI infrastructure, not just the reliance on norms and policies from outside. So I think this distinction, maybe even a slight tension between the AU's development-focused white paper and the African Human Rights Commission's resolution, which recognized the human rights challenges that AI technology and AI regulation can bring, we see played out in the regulatory landscape and some of the challenges that we're going to come on to talk to. So NanaAma will speak briefly about the data protection and IP regulation in Africa, and then we'll talk about some of the particular challenges and opportunities that we see.
The adoption of AI technologies raises really important data protection issues. It often involves the extensive collection and processing of personal data with or without the consent of data subjects, and then processing that data in innovative and often untested ways for a diverse range of purposes. Complex and frequently opaque AI algorithms also make it difficult to ensure transparency and accountability in data processing. Data subjects are often unaware how their data is processed and how decisions that affect them are made. Sometimes local companies themselves may also not be clear on how data is being processed, where they are using or relying on international technologies or service providers. So data protection laws and authorities are critical in regulating AI. And these laws and authorities oversee processing activities and safeguard data subjects' rights. Thankfully, across the continent, we're seeing a robust data protection foundation on which to build. According to a recent study on the state of AI regulation in Africa by the Center for Law and Innovation and Tech Hive Advisory, according to that study, 55 African countries, out of 55 African countries, 37 have enacted data protection laws. Two of the key safeguards included under data protection laws include principle of fairness, which ensures data subjects are protected from risks, harms, and biases, and the right not to be subjected to decisions made solely through automated processing that could significantly impact the data subject. So according to the CLI study, among the 37 African countries with data protection laws, 33 recognize the right not to be subject to automated processing, decision-making, and 30 specify fairness as a principle of data processing. Of the 37 countries, 29 have established or designated an authority to enforce these laws. And these data protection authorities are positioning themselves as key stakeholders in AI regulation. In Mauritius, for example, the Mauritius Data Protection Commission has published the Guide on Data Protection for Health Data and Artificial Intelligence Solutions. The Senegalese Data Protection Agency has published guidance on the use of biometric technologies in the workplace, including considerations for using facial recognition technology. And we expect this trend to continue. Now, on the IP front, covering a whole continent is I'm going to attempt to do that at a very high level. Yeah, the state of IP law in Africa varies from country to country, with some nations having more robust legal frameworks in place than others. Overall, the continent is still in the process of developing its IP laws and regulations to keep pace with technological advancements in general, including generative AI. In many African countries, IP laws are outdated and not well enforced generally, making it difficult for innovators to protect their creations and for companies to invest, and making it less attractive for companies to invest in new technologies. In the context of generative AI, which creates new works, as Giles mentioned, somewhat autonomously or with limited direct human input, there are unique challenges for IP law, as Giles alluded to earlier. Some countries on the continent are more prepared than others to regulate IP, particularly in the context of generative AI. South Africa has a relatively well-developed legal system and robust framework for IP protection. And they've made efforts to update their IP laws to address the emerging technologies, including AI. Kenya also has been proactive in promoting innovation and technology development with initiatives such as the Kenya Intellectual Property Institute. And they've also introduced policies to encourage research and development in AI and other emerging technologies. Nigeria has taken some steps to strengthen its IP framework and promote innovation in the tech sector. Egypt has also made efforts to modernize its IP laws and to promote innovation in the tech sector. But while these countries are considered more prepared to regulate IP, particularly in the context of generative AI, there's still a lot of room for improvement in terms of updating the legal frameworks, enhancing enforcement mechanisms, and fostering a supportive ecosystem for AI innovation. So, in order to effectively regulate IP, particularly in the context of generative AI in Africa, there are several key considerations that policymakers and legal experts have to take into account. And I'm just going to touch on them briefly because Giles has touched on them, in the global context as well. But one of the main challenges with generative AI is determining who owns the rights to the works created by the technology. Another key issue is attribution and recognition. Another important aspect is ensuring proper attribution and recognition for the creators of AI-generated works. It's essential to establish mechanisms for crediting individuals, organizations responsible for developing the AI technology and training the algorithms. African countries will also need to consider how to facilitate the licensing and commercialization of AI-generated works. And this could involve developing standardized licensing agreements for AI-generated content, establishing procedures for negotiating royalties and licensing fees, and creating platforms for distributing and monetizing AI-generated works. Enforcement and protection. I think this is really crucial. Enforcement mechanisms are, I think, very challenging on the continent. And I think across the continent, generally, we really need to strengthen the legal frameworks to deter infringement, to combat piracy, and to provide remedies for IP violations generally, and particularly those related to AI-generated works. And gosh, it's difficult to say because this is a problem generally. IP infringement across Africa is a problem generally. But, maybe deterrence, increasing penalties for infringement, enhancing enforcement agencies' capacities, and encouraging people and prosecuting crimes, and maybe promoting awareness amongst stakeholders in the tech industry may may help to alleviate the situation, ameliorate the situation. But just broadly, the lack of clarity and consistency in IP laws creates uncertainty and ambiguity, and that is something that will need to be tackled by policymakers if we are to create an IP framework across the continent that's going to promote innovation and investment. And with that, I'm going to hand over to Alex to talk to us about the challenges and opportunities in regulating artificial intelligence technologies.
Thanks, NanaAma. So this slide sets out some of what we see as the biggest challenges in Africa. Some of them are consistent with the issues that Giles spoke about that we see internationally. Some of them are specific to our continent here. So the first of those that I want to talk about is bias and misinformation. As Giles said earlier, AI systems are trained on the information and the data that is available to them. And in the context of the generative AI systems that we've seen so far, that data is generally sourced from outside of Africa. It's from the US, it's from Europe, it's from China, it's from the global north. And what exacerbates that issue is language, because most of the content that is sourced internationally is in international languages, not from content or data that is built on African local languages. And in a continent with thousands of local languages spoke in many different countries, having access to really tailored local data is a problem. And so the use of that international data is inherently going to make generative AI and other AI technologies biased, and it won't reflect the context in the African continent, and it won't reflect the experience of the people living here. And that won't be deliberate. That will just be a factor of how that AI has been trained. And so even the engineers and the people who are looking at AI technology in the US or in China, they won't realize off the back of the data that those biases are there because they haven't got any other data to compare it to. And so the challenge with having a good data set that's reflective of the African continent will inevitably lead to some biases. The second issue is access to technology. We talked before about how a lot of the AI technology that is being used in Africa, even where it's being used to tackle local issues and provide local solutions, relies underneath on some back-end technology from outside. And that foreign technology, again, is not tailored for the African situation. And so the companies and the startups who are using it locally need to understand how that bias might play out. The third issue on this slide is inequality and the digital divide. So we talked a bit about the distinction between foreign technology and African technology, but even within Africa itself, and Africa isn't a country, even within countries within Africa themselves, there is significant inequality across the continent. Some regions lack reliable power supply, as I don't need to tell anybody in Ghana, and some regions lack internet connectivity. And so this digital divide means only about 30% of people on the continent have reliable access to the internet. And so these challenges mean that if we are proposing AI or technology-led solutions for African problems, we need to recognize that that might lead to further inequality, because that 30% who are having access to the internet and reliable electricity are the ones getting all of the AI benefits. And so using AI and other technology risks exacerbating the gap between the haves and the have-nots and making that digital divide and that inequality worse. Thirdly, the lack of education and skills. Although there has been good efforts in lots of countries to build AI-focused universities, AI-focused education, that's still at an early stage. And so there is at the moment a gap in education and skills between some African countries and the outside world, which needs to be built. And so there is a reason why human capital development was the first pillar in the AU's white paper. That really has to be a focus if some of these other challenges are going to be met, because without that education and the skill base to build from, it's going to be challenging. political instability and misinformation is a problem with AI globally. We've seen it in the US with deep fakes in the election process. We've seen it in the UK, but it's possibly a potentially greater risk in Africa because of the level of development of civil society organizations and the press here may make the risk of political misinformation in electoral campaigns driving political instability greater. And then finally, the challenge I want to mention is about regulatory capacities. Although, as we saw in my earlier slide, that there has been policy development across Africa, lots of that policy development has relied on international support. And many African governments, many African regulators don't have the resources or the capacity themselves to develop detailed AI policies or AI regulations. Quite understandably, they have other priorities, ensuring electrical supply here in Ghana, tackling security issues, dealing with the consequences of climate change, or building infrastructure and fighting corruption. So these things can take precedence over AI and technology issues. And so there's a capacity gap in African regulators that needs to be filled. And the risk we see is that that gap is filled by copying and pasting international norms into an African context, which can lead to normative imperialism and African countries taking on policies, frameworks, and rules that might not suit the local context. But these are the challenges. It's not all bad news because we do think there are some particular opportunities in Africa, which NanaAma will speak about.
Yeah, so as Alex said, it's not all doom and gloom. There are opportunities. And Africa's unique situation offers many opportunities to implement AI and an AI regulatory framework that can mitigate some of these challenges. So African countries can develop inclusive and ethical AI regulatory frameworks that are integrated into broader digital transformation strategies. And thereby ensure that AI development aligns with national development goals and the Sustainable Development Goals. The risks and opportunities presented by AI can be tackled as an integral part of the continent's development strategy from day one. The continent provides a unique opportunity to take advantage of AI technologies to advance local socio-economic growth, including through the potential ability to leapfrog technological infrastructure associated with the previous third industrial revolution and a growing dynamic, young and ready to adopt new forms of digital entrepreneurship and creation. Capacity building and technical assistance. So international organizations and development partners are increasingly providing support for capacity building and technical assistance and training programs to strengthen AI and IP governance. And the AU NEPAD white paper that we've talked about observes that international development assistance remains an important opportunity for African development. And finally, innovation. Africa has a growing innovation and creative ecosystem, and the continent has been at the forefront of some recent technological innovations, particularly in the fintech sector. African businesses are problem solvers, and they're used to finding innovative approaches to address, the myriad of challenges that we face in our markets. For example, mobile money and, how that has developed to address the needs of the unbanked and to assist to ameliorate the financial inclusion. And on the innovation, in the innovation scene, technology companies are providing fintech services or agtech solutions to smallholder farmers by the likes of Complete Farmer and Farmerline, two of our beloved clients. I think with a population exceeding 1.4 billion people, and particularly the youthfulness of the population. And a youthful population that is accustomed to being connected and has been contributing to the rise of digital and AI hubs across the continent. I think this puts us in a very unique, puts the continent in a unique position. And the youthful spirit and the creativity, I think we're seeing a real creative renaissance in many areas of life across the continent. And this same innovative spirit can be applied to the adoption of AI technologies and an AI regulatory framework. The rapid adoption of digital technologies presents opportunities for leapfrogging, as mentioned earlier. Regulators also can embrace innovative and flexible regulatory models to adapt to the rapidly evolving AI technology landscape. And we are seeing some of that. We're seeing a more regulatory openness with a willingness to implement regulatory sandboxes. The Bank of Ghana has shown some leadership in this area. And we're seeing that governments and regulators across the continent are taking an increasing interest in AI matters. And so they're not sitting back, and they've demonstrated an openness and a willingness to tackle some of the complex issues that Alex highlighted, that AI technology presents, as seen in the various national policy frameworks that we described earlier. Finally, and perhaps most importantly, cooperation among African countries can help to address the lack of regulatory capacity and resources. Although an individual country may not have the resources and experience to dedicate to developing an appropriate regulatory framework, by pooling resources across the continent, this challenge can be overcome. Regional organizations such as the AU and the African Continental Free Trade area also offer opportunities to harmonize AI regulations and laws and enforcement mechanisms across borders, promoting trade and innovation across the continent. I'm going to hand over to Alex to talk to us a little bit more about the opportunities for harmonization and collaboration.
Thanks, NanaAma. So we talked about some of this earlier, so I think we can keep this one quick. And really the golden bullet is the first point, I think, here on this slide, which you mentioned, NanaAma, which is the ability to pool resources. And so even if African regulators, African governments don't individually have the capacity or the resources to tackle some of these really complex AI issues, which are being grappled with across the world, if we can pool resources, bring in international organizations to help, then that can be the first step. The second thing that we think is particularly important in African countries is alignment with international standards. Giles has talked about some of the work that's been done in China, in Europe, in the States to regulate IP. And by harmonizing or looking at those international standards and adopting them locally, Africa can make sure that trade with those countries is possible. It can make sure that African businesses can move in and out of markets easily. And that alignment can help with the development of local standards by taking into account those standards, but reflecting the local environment. And the way to do that across Africa, which is a big focus of the AU's white paper, is through harmonization.
Hello. I think Alex, I don't know. Roland, can you hear me?
Yeah, I can hear you. I think Alex is
we
having
lost
some
Alex.
challenges. Yeah, I think Alex is having some challenges.
Okay.
Maybe we can give him a moment.
Okay. Sorry about that. Just give us a moment. And I think whilst we're waiting for him to come on board, there's been a few questions, so I'll probably put it up. And I have a couple of questions as well. And I want to urge those of us here to also put their questions down. And we'll have a few minutes for the first maybe 5 that raised their hands we'll unmute them to give them the opportunity to ask their questions as well. So the first question had come in from, welcome back, Alex.
Thank you. Sorry, I thought I would demonstrate one of the challenges of AI in Africa by losing electricity and internet connectivity. But I think that's it to say on regional harmonization and regional cooperation. So I was going to pass on now to Giles to talk about what we've seen outside of Africa in terms of international harmonization at the UN and other levels.
Thanks, Alex. Sorry, I actually also just briefly lost connection. Can you hear me, or have you got an echo?
Slight echo.
I think okay. Thank you. See if I can try and solve that. Are you better or
It's fine.
Thanks so much. Look, I'll carry on. So maybe just to pick out 2 themes from this slide. Firstly, there is a lot of international cooperation around safety. And the concern is that certain types of what at least the UK and others call frontier AI, that is AI that could be used to produce kind of dangerous items, is not necessarily kind of properly called out in regulation
Giles, I
across the
think
board.
we have 2 of you opened, so I don't know whether we could mute, because I see 2 of you here. So if we could mute one, and then it will minimize the echo.
That's fine. We'll just a moment.
Okay.
Hopefully you now only have one of me.
Yeah, I think it's fine now.
So as I was saying, there is certainly an international effort to coordinate on safety. And so you see that driven by safety summits that took place last year in the UK, which will take place in Korea shortly, and then later in the year in France, and then collaboration around the reviewing of large foundation models, particularly by UK and US AI safety institutes. The second piece to call out is that in a large amount of the international cooperation, and I know that we've discussed this briefly on the call already, there is, I think, at least a perception that that is taking place across the global north in isolation. There are, I would say, the beginnings of efforts across the G7 and the UN to make the discussion around AI regulation globally a much more international effort. So you see, for example, that from the G7, there is a meeting in April this year between the G7's Italian presidency and a number of African Union officials with a view to strengthening the collaboration between the African Union and the G7 nations. And then at the UN level, which you would think of as a natural home to ensure that the approach to AI is being led in an inclusive manner, there is an expected report due this summer that will explain a number of guiding principles that the UN proposes for the development of the governance of AI internationally. And one of those guiding principles is exclusivity. And the aim there is to have broader buy-in across UN participating countries, that all citizens, including those through the global south, should be able to access and meaningfully use AI tools. So I think whilst there is really a flood of kind of good intentions in the kind of AI governance space internationally and often supranationally, I would call out those 2 as being more directed to greater collaboration between some of the countries in the north that are more associated with the kind of AI foundation model innovation and the rest of the world. With that, I'll pass back to the team on takeaways. Thanks so much.
Thanks, Giles. I think we've touched on the same themes a number of times. AI presents a number of opportunities for the continent in addition to a number of risks. And there's a lot that we can do together regionally to pool our resources in order to make up for some of our shortcomings or challenges in resources and capacity. And yeah, in the words of Helen Keller, together we can do so much. So with that, I think we've run out of time. So I'm going to hand over to Teki to take us through the Q&A. Thank you.
Thank you very much, NanaAma, Giles, and Alex, for this very comprehensive webinar. I mean, a lot of questions have been going through my mind, and I believe a number of our participants also have questions. So for the participants, if you haven't had any opportunity yet, kindly put your questions across in the Q&A part, and we'll try as much as possible to answer. Also, I'll give opportunity to the first 5 that will raise their hands to ask the panelists questions about whatever they've spoken so far. And I think I'm going to read the first question, which is coming from Honorable Safari, who is a member of parliament in DRC Congo. And his question is, who owns IP in AI? AI developer, AI user, owner of the data used to train the AI, or the AI itself? So over to you, ladies and gentlemen.
I'm happy to kick off that discussion if it's helpful. And it is actually, as I said earlier, one of the harder points that people are trying to work through at the moment. So it's a great question. I actually tend to start at the other end of the telescope and ask, what types of things in the AI value chain are you trying to protect? Are you trying to protect the training data, the model, some other aspect of the AI system, the prompts that users are putting in, or the output from the system? I think you get a different answer for each of those different parts of the AI system. So the training data, if it can be protected by IP, would often be protected by the person who has collected that data, and you get different types of protection for databases in different parts of the world. Obviously, copyright content will be owned by the usual author or subsequent owner of that right. When you look at the models themselves and the systems around them, then they will typically be owned, insofar as they are an IP right, by the people who have sort of initiated the building of the model, the design of the model, the way in which the data has been used to create the model, and so on. And you can't rule out the potential for patent protection for some of those models or ways of working, or at least the systems around them. The prompts, those are the things that you and I will put into an AI system all the time. Copyright law will usually say that they're owned by the person writing the prompt. And I suppose if that person is an employee, then that IP might get allocated somewhere else. But there's quite an interesting question about who gets to use the prompts, because actually the prompts are quite valuable because they enable you to refine the models over time. And then I think I've probably already bored people with my thoughts on who owns the output from an AI system. The harder question, I think, is whether or not the output from an AI system actually infringes someone else's IP, because you do see fragments of existing inputs finding their way into outputs, and that is particularly an issue for the software community, where there has been significant generative AI adoption to code, and you will see in commercial offerings certain filters that limit the amount of original code which is included in an output, with a view to trying to avoid that copyright infringement risk. But that's my helicopter view internationally, but gladly hear from others.
Thank you very much. I think we have another question. Let me see. What are some of the potential solutions that could address the challenges of the intersection between AI and IP?
I'm happy to offer a couple of thoughts. Obviously, we see in the regulation already asks from regulators to have further disclosure from those who are creating large foundation models as to how those models have been trained. I think that there's a regulatory piece there around transparency, understanding the risk of bias and so on, which I appreciate resonates particularly in Africa, as Alex and NanaAma were explaining. And then I think there's a handoff to IP law. I think that some of the main rub between regulation and IP has been around the training of large models. But I wouldn't rule out that there are specific opportunities for smaller models where people might have a particular knowledge locally, which is relevant to a particular country or a particular sector, where actually you have proprietary data associated with that sector, and you can build a brilliant model associated with that thing, and so there's value in monetizing the data, which is then licensed, and there's value in the model. You see it already in medical science, where people are looking at using kind of data from X-rays, from MRIs, as a way of identifying kind of future medical risks. So you build a model around a discrete point, and there's an opportunity for people who are building up data, and that could be in a particular locality or in a particular field.
Yeah, that's interesting, Giles, because that's exactly one of the things that is talked about in the AU Development Agency white paper, where they talk about using localized models either on a country-by-country basis or on a sector cross-country basis in Africa as a way to deal with some of those IP challenges. If you can find either open source models or licensing models that you then use on your own data.
And there's a related good point there, which is that the smaller the model you use, the more likely it is to be accessible to people who may not have the same compute power to actually kind of develop and evolve it, and so that there is perhaps more of a democratization to what you can create.
I mean, I think the only thing that I would add to what's already been said is it depends on where you are and the state of the legal framework, the IP framework as well, when we start to have these sort of more detailed discussions.
Okay, thank you very much. So I think we have one more question from Richard, and I've been dying to ask a couple of questions. So I just want to throw them up and then add Richard's own, and we'll see how we could develop that. My question is really looking at the African landscape, and based on what you've shared so far, I think as far as IP is concerned, maybe we could be ambitious to say that we're not necessarily, as far as AI is concerned, engaging a lot on the IP discussion. So my first question is, what are your thoughts about this? Do you think that as far as AI is concerned, of course, looking at the continent, there are a lot of initiatives around policies and strategies and all of that. Do you think that we're really engaging the IP issues enough around there? And if we're not, is it important, or is it something that is not necessary? Also, IP is a highly regulated and a very technical area. And looking at the challenges that most of our countries face, particularly around enforcement of our laws and the kind of resources you need to be able to enforce IP laws, do you think that, one, the existing IP laws and resources are sufficient to address AI issues within the context of our respective African countries. Of course, bearing in mind that some of the countries are more advanced than others. And then the last question, which is from Richard, says that, do you know any concrete steps African governments are taking to ensure that we have the infrastructure to store the requisite data we need from AI? So that will be it. I think anyone can take it up.
That was a lot of questions. I'm struggling to remember. I think that's about 2 or 3 questions. Could you?
That was like 3. The first
Okay.
one has to do with generally around, of course, looking at the policy landscape and what is happening across Africa. Do we think that even with the current development around AI, we're engaging enough on the IP issues with regard to the policies and the strategies that are out there? And then also whether you think that we have enough capacity and resources to implement IP in the context of AI in Africa.
Yeah, I think the answer to that is no. I think there is a lot of conversation happening around AI and some very thoughtful work that's going on. But my sense is that it's sort of siloed. So we're talking about AI, and we're not necessarily talking and focusing enough on the IP landscape, which even when we're not talking about AI, we have some challenges in the IP landscape, as you mentioned, Teki, enforcement, awareness, and so those things persist. And when you layer on AI and the complexities around AI, my view is that we're not engaging sufficiently and paying enough attention to. I think there is awareness of the challenges posed by the insufficiency of the regulatory framework, but I don't think we are yet sufficiently equipped in terms of resources and capacity to really address the problem. Alex and Giles, I don't know if you have any thoughts.
I was just going to say, one of the things that the white paper was the need for the still relatively new Pan-African intellectual property organization to tackle some of these challenges by pooling the resources that are in PAIPO to do that regulatory heavy lifting that countries haven't yet had a chance. So maybe the regional Pan-African IP organization could be the solution to some of these country-by-country problems.
I would only add that I wouldn't assume that the rest of the world is getting this right in a coordinated way either. I think particularly on the IP problem that is currently bubbling up as litigation in national courts, and it is in that disparate way that people are deciding questions like, can an AI be an inventor for the purposes of patent protection? Usually no, it seems to be the answer, but it's kind of odd that is basically kind of litigated, and sometimes litigated very deliberately just to try and get an answer to that question. The same is true of the copyright litigation, which is ongoing and for which there are very different approaches to kind of copyright infringement defences. The only other thing I would say is that there's quite a lot of lobbying internationally from both sides of this kind of business equation. So creative industries and innovative industries alike, both very interested to make sure that their voice is heard. That inevitably means that it's quite hard for a government to speak with one voice, because actually they get pulled in opposite directions by industries that they are trying to protect. It may well be that you find that you have a similar kind of pull in multiple directions across the continent where you are.
Thank you so much, Giles. The final, I think Richard's question, we haven't answered it yet. He's asking, do you know any concrete steps African governments are taking to ensure we have the infrastructure to store requisite data we need for AI? I'm not
Thanks,
sure.
Richard. Question. Shall I take that one? Because
Yes,
it's something
please.
that is picked up a bit in some of the national AI policies that we talked about earlier. And Egypt in particular has really been at the forefront of this. So to make a data center work, you basically need three things. You need connectivity, you need electricity, and you need cash to build it. And the Egyptian national AI strategy, at least as we see it from outside the country, is trying to address those three things. So there's funding initiatives to try and allow investors to make capital investments in data centers. There's power initiatives, particularly with the use of off-grid solar. So the recent Egyptian hyper data center that is being built is intended to be funded by off-grid solar, which is built on top of that data center. And so there are regulatory solutions to make that easier. And then connectivity by trying to provide guarantees on international connectivity for data centers that are built there. So some countries, to answer your question, Richard, yes, are taking real concrete steps to address those three needs to build data infrastructure here. But there could certainly be a lot more across the continent and closer to home here in West Africa too.
Okay, thank you. For the attendees that are here, if you want to ask a question, I'll just give you maybe a second or two to raise your hands, and then we will unmute you so you can ask questions. I can take, I think, looking at the time, we can take maybe one or two questions. If not, we will just allow our panelists to just give their closing remarks. All right, ladies and gents, I think you've done a brilliant job. No one has any questions. So I'll come back to you for some final thoughts around this whole issue of AI and IP in Africa. And, you know, this gives you opportunity to go out of text or maybe share some reflections or things that you think we should be thinking about going forward. So over to you. I'll start with Alex, and then Giles, and then NanaAma.
Thanks, Teki. I think what's really interesting coming out of this webinar for me, Giles touched on it right at the end there, is that these issues with regulating AI and the intersection between AI and IP are issues that people are grappling with all over the globe, and nobody yet really has the right answer, if there even is a right answer to how these things can be regulated properly. And so in that context, the challenges that Africa is facing with its own regulatory strategy, with its own policy strategy, are challenges that we see elsewhere. And so lessons that can be learned in Africa can be taken internationally, lessons that have been learned internationally can be taken here. And I think seeing how those international approaches can work with the local context and vice versa, how the lessons we learn in that local context can work internationally is going to be really interesting to see.
Thanks, Alex. Okay, we did take the baton next. Look, firstly, thank you very much for inviting me to offer an international perspective to those of you in the continent. Like what I see, to Alex's point, is a lot of uncertainty and a lot of discussion which is still evolving. I think I personally find it very helpful to reflect on what the levers are for that discussion. So and I'd call out 6. I'd say firstly, what does it take, and how should we protect innovation? Secondly, as regards AI, what risks are we worried about? Thirdly, what mitigants are we going to ask innovators in this space to take to mitigate those risks? Fourthly, who in the AI value chain should the rules apply to? You know, we've rightly had questions about developers, users, different layers of implementation, who should be required to do what by different laws that we're putting in place. Next, how much of that is urgent? There are quite a few countries around the world that ask themselves the question, well, should we wait and see? Should we regulate on all of this now? Should we regulate on some of it now? And then finally, how much is actually best left to businesses and voluntary codes versus how much should be mandated by particular countries? I think you're hearing across different African countries approaches that are kind of based on guidelines or quasi-voluntary and not yet hard law, and that may well be the right approach. I think you can have a system that has multiple speeds and different ways of approaching it. And I see those sort of 6 levers pulled in very different ways across the world. So it's fascinating to compare notes with the group here.
Thanks, Giles. I think from where I sit, there's a critical window of opportunity, and things are developing so quickly globally. So I think there's a real urgency and a need for African governments to come together to insist on a seat at the table as these issues about the responsible use of AI are being discussed. Because although we have a lot of innovation on the continent, most of the technology is being developed elsewhere, and we are the consumers. And so it's super important that we have our voices heard. And it's very important that we start to come together and to take positions on how we want all of this to be regulated, because it is going to impact the manner in which Africa develops. I think it's going to have the largest impact on Africa and our future and our development. So I think it's really urgent, and I applaud you, Teki, and everybody that's making an effort to raise awareness and have us think carefully and critically about the importance of regulating AI and for Africa to have a seat at the table.
And thank you very much for joining us. It's for people like you that make webinars such as these successful. We know that these expertise across the continent is usually very difficult to come by, and that your timing is never really available. So we really appreciate you joining us and really supporting this course. As a takeaway for us, I think that what this webinar really brings, and it's similar to a number of these sessions that we have, is that it really unearths the fact that there are challenges, there are uncertainties, and clearly this is an evolving space. And for us, that is why these conversations, we must start having these conversations now, and we must do it as often as possible. And it's also important to get the policymakers to start really thinking about these issues. I was quite happy that today we were joined. We don't have the opportunity of knowing everybody that joined us, but we were joined by a member of parliament from Congo. But it's very critical to have the policymakers also really understand these issues that sometimes as lawyers, as experts in this area, we speak over their heads. And I think having opportunities like this gives us the opportunity to break some of these issues down, to help them also understand how we can address it within our local context. But as like closing remarks, I just want to thank everybody that was able to join us here today, particularly you, Alex, Giles, and NanaAma. We will definitely knock on your doors again, because I realized that we had a very short time. Maybe we need to explore going into more details around specific issues and specific actions that can be taken. But we will come back again, because as far as ADRH is concerned, the biggest challenge we've seen in the areas we look at when it comes to digital rights, the data protection conversations are ongoing and growing. The cybersecurity issues are heightened, but when it comes to intellectual property, we are still not doing enough. And so we think that, and it's also a very critical factor, especially if we want to enable innovation and growth in the digital space across the continent. So we will definitely come back to you to talk a bit more about some of the details that we didn't have the opportunity to explore today. Thank you very much. And for the panelists that have stayed with us, joined us from the beginning and have stayed with us, we really appreciate your time. Please do well to follow us on our social media pages, and over there we share more information about the next webinar that will be coming up, and also some other information. I must also say that this piece is recorded, and so it will be available on our YouTube channel. So do well to follow, and you can have the opportunity to go back, because I think I'm going to do that as well. There's been a lot of learning here. And so thank you all for joining us. And until we meet or reconvene here again for another webinar, thank you, ladies and gentlemen, and the attendees. Have a wonderful afternoon or evening, wherever you're joining us from. Bye.
Thanks.